does so, that it excludes uh, uh, rationally first degree from among first degree murders within that particular aggravator. And as I understand Hairston, it's just not a relevant issue. It's not a legally, it's not an issue that upon which the question turns.
Well, Hairston was decided,
That I'm a trial court and not the Supreme Court.
and I'm sorry I interrupted you.
No, that's
Hairston
okay.
was decided in 1999, which was a long time before Hidalgo was decided. And so the United States Supreme Court has absolutely made the issue ripe and said we want to hear what the specific data is, and we extend the invitation for that to be done. The study in Hairston was framed as, did Idaho's method of compelling financially burdened counties to bear the cost of litigation in capital cases result in arbitrary and
That was
capricious
the claim of
application?
geographic discrimination.
Pardon?
Wasn't that the claim of geographic discrimination?
It was based on money and whether or not an urban
That's
versus a
different from
non-urban.
the issue of what the relevant legal framework is with respect to whether or not the aggravators are overbroad or over inclusive.
I
as a
agree.
whole.
I agree. But before we get to even there, Judge, which would come under our motions to strike, the heinous, atrocious, and cruel, and utter disregard, and propensity, the other motions that we have before you, we first have to focus on the eligibility and looking at eligibility of the death penalty in the state of Idaho, which is a legislative function that looks at the statute and then the aggravators as a method of narrowing, and whether or not that results in arbitrary and capricious application for purposes of the Eighth Amendment. And that's what Professor Cover's study addresses.
Correct. It doesn't address whether an individual aggravator is itself overly inclusive. It doesn't do it based on, in fact, she generalizes the aggravators as quote unquote the fuzzy ones, I think is what she called it. And then the, I can't remember what the name.
Clear.
The clear ones
Right.
were.
Right. But it is her study is a good foundation when you're get into the next level of looking at those aggravators and the definition of fuzzy and what that really means in terms of the analysis to strike those individually. So we have to begin with looking at whether or not we should even be getting there in the selection process.
Right. But I guess my concern is that the Supreme Court, the outer Supreme Court, has said that that's not the issue. When we look at whether the aggravators are unconstitutional as being not sufficiently narrowing of the class of persons or crimes available for the death penalty, the Supreme Court specifically rejected a approach that is based on the cumulative effect of the aggravators together. It said you have to look at each individual aggravator and ask with respect to that aggravator, does it exclude sufficiently? Am I wrong about that?
I don't disagree with what your statement is. I'm saying that we've got to start before that with the analysis of who is eligible
Right, but that's
to
the
be
point.
charged with the death penalty.
That's
But it begins, Judge, with the definition of first degree murder. You start with the definition, which is very broad, of first degree murder,
which is why the aggravators are required.
right? And then you look at what happens within those aggravators. And we are arguing about the individual nature of those aggravators in other motions. So, these are different arguments.
But you, in those other motions, didn't rely upon Dr. Kohberger's article.
No, that's true, but it still comes to the issue. You still have to look at the issue of eligibility before you get there.
But the aggravator is the eligibility.
It's part of the analysis.
I
of
mean,
the
everyone agrees the
eligibility.
statute itself as to first-degree murders that are eligible is without more unconstitutionally vague. That's why the court has, U.S. Supreme Court then later approved statutory aggravators, including with judicial gloss, right? And so then the question, the court has said, the Supreme Court of Idaho has said, and the Supreme Court of Arizona has said is, and other courts, not whether, when you look at all the aggravators together cumulatively, do those sufficiently narrow? The question is, when you look at an individual aggravator, does it exclude first-degree murders from it? Does it narrow first-degree murders? And you look at those each individually and not cumulatively. My understanding is that Professor Kohberger's analysis is that taken as a whole, these don't accomplish that. Is that accurate?
I would yield to her to testify to that, Judge.
Well, I've read our law review article, and that's what she says.
That's the purpose of having her testify. I think that it comes in segments, and you have to begin with the definition, then you have to get to the aggravators, and then you have to look at what is the quantity of cases in Idaho that fall within both of those, pair it against what the result is for it being arbitrary and capricious. And when you're talking about our court, the Hidalgo case is from the United States Supreme Court, post-states what our court said in Hairston.
The other concern I have, I'll save that. I'm just now thinking about whether I need Dr. Kohberger. Why can't I rely on her law review article as a proffer of what her testimony would be?
Well, Judge, you are the trier of fact here, and it's important that you listen to, I believe, to make a reasoned decision, hear testimony, and hear that testimony be confronted and cross-examined. And that's what the United States Supreme Court said. I mean, if the state were to stand up here right now and say, hey, we concede, the statute's overbroad, the aggravators 11, everybody fits. What the United States Supreme Court has said is, we appreciate that concession, Arizona. It may genuinely exist, but we are a justice system where we want to hear that data talked about. We want to hear those issues confronted. We want to hear that debated. And so as a trial judge in this case, this is the appropriate time for you to hear that so that you can make a reasoned decision, not just based on her paper, but based on her explanation. One of the arguments that the state has made is that, we don't know what she's gathered, what her methods are. Well, she'll be able to testify to that, to explain that to the court, what her approach was. And it was different than what happened in Hairston years ago. And so for that reason, this court should hear that so that you can make a reasoned decision.
Your Honor, I'd like to address the foundation issue, because even if this court were to use the denial of cert in the Hidalgo case as a basis to delve into this issue at this time, Professor Kohberger's data does not provide adequate foundation to be reliable enough for the court to do that. And what I mean by that is that if you look at the Excel spreadsheet that was provided as an exhibit, I would direct the court's attention to just 4 examples. Line 22, the Nuxall case, death notice was not filed in that case. And Professor Kohberger did a review of the documents that were available to her and labeled that case as clear hack. Now, the significance to her designation as clear hack is that elsewhere, when she designates cases as hack or utter disregard or propensity, which she describes as fuzzy aggravators, she doesn't designate everyone as a clear aggravator. She only designates this one in particular and potentially others as clear, which then calls into question, well, are the others not clear? And potentially did the prosecutors who were determining whether or not to file death perhaps have more information available to them that enabled them to determine that in fact that those aggravators did not apply. The next I would direct the court's attention to would be the Huntsman case, line 33 in that spreadsheet. That case was labeled utter disregard / propensity ? Again, if Professor Cover can't determine for sure whether or not these labels apply and has to place a question mark in there, and she's relying on the court record, not necessarily the entire body of evidence that the state would have had before it when it determined whether or not to file that notice, again, she isn't even sure herself, at least according to the spreadsheet, if those designations apply. Carlos Alonso Sandoval, line 44, her notes indicate possible hack. No death notice was filed, and according to that spreadsheet, it would have been included in her study. Yet she writes possible hack. And there was no clear aggravator in that case, I believe, Your Honor, which means that, again, we're including this case based on the fact that she's designating that it might apply, possible hack. Finally, I would point the court's attention to line 52, Angela Cervantes. The state did not file a notice of death in that case. Now, there was a clear aggravator, according to her, for kidnapping. But again, when she lists whether or not a fuzzy aggravator applies, she writes utter disregard with a question mark. Again, Dr. Cover is relying, according to her article, on documents she was able to obtain from transcripts from the state appellate public defender's office. She did not indicate in her article that she had, I don't think she even argues that she had the same body of evidence that the prosecutor would have had in each of those cases, making those determinations. So what's essentially happening, and this kind of brings us full circle to the legal analysis issue with all of this, is that she's reviewing court records, making a legal determination that's different than the prosecutor who made that determination whether or not to file a notice of death, intent to seek the death penalty. This is not a reliable body of evidence upon which the court could even make that determination, if the court even wants to consider it as evidence, which in the state's position, it's really just a legal analysis where Professor Cover is just reaching a different legal conclusion based on court records and providing a statutory analysis. And so the state would just argue that her article is a sufficient proffer. We would ask the court to grant the state's motion and to disallow her from testifying today. Thank you, Your Honor.
Thank you. Rebuttal? Oh, actually, that was the rebuttal, wasn't it?
If you'd let me talk,
I will indulge you for,
Thank you.
my schedule is already shot to hell, but we'll indulge you.
Judge, we will be able to get through in one day. I think that the argument that the state just made feeds my point, which is they're drawing conclusions off of the raw data without talking to the expert. When an expert provides their spreadsheets and has notes without asking Professor Cover what a question mark means, what the exact records were, why she used those records, why the conclusions she drew were drawn. First of all, you don't have the exhibit because it has not been admitted. It's been provided to them because they were raising issues about wanting to see the data. Or if she's allowed to testify, she can talk about that.
This is the data that she used with respect to her law review article.
Correct. To draw her conclusions and do her study. And so,
And that law review article was as of 2019?
yes, yeah, yes. And so I think that the state just actually made the exact point that I'm trying to make to you. Thank you.
So since I have you, you brought up Hidalgo, and you talked about the Supreme Court doing this. My reading of Hidalgo is that cert was denied. A minority of justices issued their own statement in which they thought it would be important to gather additional information. The court itself did not. Am I correct about that?
Well, you're correct that cert was denied, but Hidalgo has been viewed across the United States as an invitation. It's not just Idaho that's done this, done a study. You know, other states have done the same at the invitation of the Supreme Court.
An
because
invitation of 4 of 9 justices of the Supreme Court.
Correct. It's still an invitation, and it's been accepted as an invitation.
Thank you. So I don't find that the proffered testimony of Dr. Cover will be relevant or helpful to the court to decide this issue. I think that I can rely upon her law review article and the data that I understand that has been provided today as a proffer of what that testimony would be. Of course, the constitutionality of Idaho's capital sentencing scheme is a question of law. Whether to allow expert testimony is committed to this court's discretion, specifically the well-known 4-part My Fun Life standard. Opinions as to the law are generally not admissible by experts. The court is the determiner of questions of law and not what somebody else's opinion of what the law is. Opinions of what the law is are received by the court through counsel, not through expert witnesses. And so generally I would not have permitted expert conclusions about the law. And therefore her opinions are neither relevant nor helpful and therefore not admissible. Importantly, of course, as we've talked about, Idaho has opted to satisfy the constitutional narrowing requirements from the U.S. Supreme Court through the adoption of statutory aggravators rather than through narrow definitions of capital offenses. The relevant, as I understand from reading her article, Professor Kohberger's analysis is offered to support the argument that collectively Idaho's statutory aggravators do not sufficiently narrow those first-degree murders, which would qualify for the death penalty. But that is not the question that the court must answer. The relevant question is whether a particular individual aggravator provides a principled basis for distinguishing between those who deserve the death penalty and those who do not. The Hairston case, I believe, makes that clear. The court is bound by binding precedent of the Idaho Supreme Court on this issue. And therefore, I don't feel the need to take Dr. Kohberger's testimony. I think the issue is sufficiently preserved through her law review article and the data that was provided. Now, if I look at this when I write this issue up, I certainly can invite counsel and Dr. Kohberger back at a later date to provide that information or to help clarify some of that information. So from that perspective, I don't think Dr. Kohberger's testimony is needed this morning. Now, I'm not going to preclude the argument on the merits using Dr. Kohberger's analysis, because certainly counsel has the right to make a record of their argument on that as well. And so I will hear argument on the merits of the motion to strike the aggravators writ whole. This is not the argument on the individual aggravators, but on the collective aggravators.
We are asking the court to strike the death penalty because in Idaho, there is no narrowing of eligibility, which results in arbitrary imposition of a death sentence. We are also asking the court to strike the death penalty as a violation of the Equal Protection Clause. I will argue narrowing first. When it comes to the determination of eligibility, it begins with the definition of first-degree murder. And when the definition of first-degree murder is looked at, then the next thing that happens is looking at statutory aggravators. And the reason that those two things exist in Idaho and those steps in analysis exist in the United States is because of the Furman case. It's important to distinguish between eligibility to be charged and selection, which is at a post-conviction phase of a case. And so our argument and our focus for this issue is on the eligibility phase. What
Your argument
defendants-
doesn't consider the weighing of mitigators against the aggravators is what you're saying, and the appellate review available. You're simply focusing on whether collectively the statutory aggravators narrow the class.
Let me answer the mitigation question first. Mitigation is in the selection
Right.
phase.
That's what I'm saying.
So I'm not arguing about that. I'm going to step and grab my water.
Sure.
I want to be clear about the argument and eligibility that I'm talking about the definition of first-degree murder and the aggravator statute, because our definition is so broad that there is no narrowing there. And so that is an important first step that the prosecutor in their discretion, they're looking at, and there's essentially no guidance with the first degree definition. And so you do get to the narrowing factors, which is the duty of the legislature that cannot be abrogated to any other branch to fix when there is no proper narrowing. Professor Cover concluded that when you analyze those things with the 195 cases that she reviewed and collected data on against the number of death verdicts, which is so low, that you end up with a statistic that is worse than the statistic that the Supreme Court struck down in Furman.
Well,
And
so the Furman's an interesting decision, right? Because while I recognize two of the justices talked about those specific statistics, I don't know that those specific statistics are in fact a binding opinion of the court. There's much more in Furman apart from the statistics that two justices relied on.
And I don't disagree with that, but it's certainly guidance for the court. You know, when you're not hearing testimony from the expert to explain everything that was taken into consideration in the conclusions that she drew, then what I'm going to do is take it at the high level that Furman is the guidance of those statistics. Her statistics show that Idaho's were vastly worse, and so it's certainly something that the court needs to take into consideration in terms of whether or not there is the ability to narrow in the state of Idaho. The conclusion from the expert who did the study here is that there is no narrowing.
And my question was more a legal one, which is the analysis by Dr. Kohberger in her extensive law review article takes as its starting point that you have to have a statistic below that identified by the two justices in Furman.
Your Honor, I guess I disagree that that's where she draws a hard line there. I think that it's guidance.
Okay.
And there were other states that she looked at that she could certainly, if she testified, explain what was going on in all of the things that were going on in her analysis. But I don't know that my interpretation is that there's this hard and fast line But certainly we have a line that the United States Supreme Court looked at, and Idaho's is worse. So the problem when you have no narrowing is that instead of it being a situation where the worst of the worst are being charged with the death penalty, everyone falls within that category. And that cannot be remedied by anyone else other than the legislature, because that is their duty. And if there's no narrowing, then and it's arbitrary, then that's a basis for this court to strike the death penalty. There were, when Dr. Cover did her study, she looked at other states that did a better job of narrowing in statutory aggravating factors. And I want to give the court an example of what that looks like. In the state of Oregon, which actually is on pause with its death penalty right now, a narrowed statute there is the murder of two or more people or terrorism while in custody and after a previous homicide conviction, premeditation and against a child under 14 years of age, or premeditation and against a police officer or another officer. So that's an example of how a legislature can certainly make an attempt at getting factors much more narrowed and tailored. Now, Oregon's hasn't been, as I understand it, has not been taken up on appeal, so it hasn't been analyzed at this level, and the death penalty is on pause there. But it is an example of a statute that can be narrowed. The other thing that I wanted to point out is that the state of California versus Tulipa, and I hope I'm saying that name right, has a statute for aggravators that in and of itself carries a whole bunch of mitigating factors for the state to actually take into consideration. So the state doesn't wait until it's very clear that the state is looking at what only happens in Idaho at the selection phase and not the eligibility phase. The other point that I want to make about our motion on this is the issue of geography. And I want to point out that we are arguing geography in the context of equal protection, which is a unique argument that has been made in Idaho and has not been addressed on appeal when it was being raised in Harrison over financial resources, and the point was geography. It was in the context of arbitrary and capricious, and not in the context of equal
But as I
protection.
understand your analysis is that the geographic, there's a predilection for capital cases to come from geographic centers of large populations, correct?
Correct.
Client's case does not stem from one of those.
That's true, Judge, but this is not, we're not talking about the facts of our client's case right now. We are talking about Idaho's
Your claim
statutory
is
scheme.
on the whole, your claim is that it violates equal protection.
Correct. And not only on an Idaho level, but also on a national level, when you take into consideration how many states have stopped using the death penalty or paused using the death penalty. So it's geographical at a state level, and it's geographical at a national level.
Interesting. I think the last 3 or 4 death penalty cases have come from outside those geographic centers in Idaho.
In terms of the southeastern Idaho,
2 in southeast Idaho, and I recognize one was death penalty was taken off the table for reasons outside the control. Well, I suppose not ultimately outside the control of the state, but because of the state's failure in discovery. This case, and then I believe there was another one up in the 2nd district relatively recently that then was resolved.
and I can't dispute that. That still does not eliminate the fact that in Hairston, the Dr. Jensen concluded that there was a geographical issue. And in Dr. Cover's study, she made observations about geography as well.
But even she's confessed she couldn't make any conclusions based on that.
And that was why I used the word observation. And had she testified, she would have explained her observations regarding that. But it is instructive to see that a study that was conducted in 1995 in Hairston has the same results in 2019, even if it's just an observation about geography. One of the things that the Supreme Court mentioned in its decision in Hairston is that they really wanted more information about the data that had been gathered and the reasons that there was a determination by Dr. Jensen regarding that and more analysis. But nonetheless, that was Dr. Jensen's conclusion, and they are Professor Cover's observations. For those reasons, we are asking that you find, based on Professor Cover's study, taking it at face value with its conclusions and providing you with the data that we will look at and redact
If I
names.
go there, in other words, if I accept that there's an actual valid analysis to be done here, would you agree that I need to look at cases since 2019 as well?
I think, Judge, that the point of bringing in an expert today to talk about a study is that that's her expertise in gathering the information and putting it into a compilation. For you to engage in that on an individual basis,
Well, I can't take her opinion because it's a legal conclusion. Looking at her data, which is 5 years old now, it seems to me that if I were to engage in that, I would have to look at the data as of today and not as of 2019.
yeah, I guess I'm not willing to concede that. And if it was something that needed to be undertaken, I'd like to have the opportunity to have Professor Cover testify about
She's
her
got no
time
opinion
frame.
about that.
Pardon?
She's got no opinion ultimately about that. She has some data that she collected that she thought was interesting and might require some additional study. I guess the point is that if I were to engage in that, it seems to me relevant, at least as to the state claim for, claim that the state equal protection, not the state equal protection clause, but the equal protection as applied within Idaho geographically, would need to look at that as of the time frame now.
Well, it could certainly be instructive, Judge, but if you're taking the data from Hairston, which was 1978 to 1995, and Professor's Covers from 2002 to 2019, the data, if it was analyzed, I'm quite certain would support both of their premises. I haven't analyzed it. We could have that study done, but I think that there's enough guidance with all of those years of data to be able to draw the conclusion that it's arbitrary and capricious today, because the statutory language is still, the definition is still the definition. The statutory aggravators are still the statutory aggravators.
have a case that indicates that an equal protection analysis can be applied on its face as opposed to as applied? Because my understanding is an equal protection clause has to be analyzed as applied.
Yeah, I'm not able to, I can't right in this moment give you that case. I'd be happy to look into that and submit it as a supplemental authority.
You would agree if it is as applied, that would put your client's claim, at least as it relates to within the state of Idaho, as not being problematic, given that he's from one of the smallest districts in the state.
Well, the, then I want to go back and talk to you, Judge, about the premise in Hairston, which was pre the Capital Defense Fund, which also has created, in time, another dynamic of whether or not someone's charged with the death penalty and those costs at the time that he was charged. I mean, now it's different. So yeah, I'm not going to concede that as applied, it just simply doesn't fit. I think that there are greater questions than that, but I don't have a case to point you to exactly. I don't think that has been, it hasn't been raised in Idaho. We're making the first equal protection. I mean, in other district court cases in North Idaho, Mr. Logston has raised this issue. So I don't want to say
Rejected
you're
in
the
those,
first.
in all of those.
Right. But it hasn't made it to the Idaho Supreme Court, to the appellate courts.
I just don't see how, as applied, you've provided the court any information where I could conclude that because your client is from one of the geographic districts you claim is the does not get its fair share of capital cases.
And we did not submit that argument in our brief.
All right, thank you. I think you've used your time.
Thank you, Judge. I'll try and keep this brief. I think there are two problems, independent problems, with the theory that the defense is articulating here, and they both come from Idaho Supreme Court decisions. The first, as this court has noted, comes from Hairston, where the court said this just isn't how you do the analysis. You don't cumulate them and then do
What's
the analysis.
intellectually wrong with that analysis, though?
With cumulating and then
I mean, I understand the legal cases may not be supportive of the defense's claim, but from an intellectual analysis, if the point is to make the death penalty less arbitrary,
correct.
Why wouldn't you look at the net or the cumulative as opposed to each individual compared on its own in isolation?
So, Your Honor, I think to answer that question, looking back to kind of how this was developed with the aggravating factors, the idea behind the aggravating factors is that you have to be able to show that this person is morally worthy of the death penalty. And so if you have individually analyzed every single factor and every single one you found constitutional, then it doesn't matter if in every case you could apply one of those factors, because that factor is a reason why that person is morally worthy of the death penalty. And so it's not an arbitrary and capricious system. It's not left to the whims of somebody.
But if you have so many aggravators that on the whole would essentially apply to any first degree murder, then isn't it just left essentially to the prosecutor as to which cases are or are not worthy to bring as a capital case?
So absolutely, the prosecutor would have a lot of discretion in that. I don't know that I agree with the characterization that it's left to the prosecutor, because of course the prosecutor has to prove that aggravating factor beyond a reasonable doubt. And if they can prove one of those aggravating factors beyond a reasonable doubt to the jury, and the jury finds that, then that person is now worthy of the death penalty. And again, when we instruct the jury, we don't instruct them to consider all of the aggravators in the aggregate. We tell them you have to consider them individually. We tell the state's required to present non-duplicative evidence for each aggravator that it's going to assert. It can't just throw out a blanket of aggravators. I think focusing on single aggravators is consistent from beginning to end of our entire system. And so I don't see a problem with that analysis that the Idaho Supreme Court said that that's not how you do this. And I would note, I think the court has mentioned this as well. It's not just the Idaho Supreme Court. There are many courts who have rejected this approach. The defense hasn't been able to point to a single court in any state, in any jurisdiction, that has used this cumulative approach to attack the death penalty or the statutory scheme of the death penalty in any state. So I think the court was right in Hairston. Clearly, it's binding precedent. You know, the defense in their reply brief, they tried to say their response to Hairston was, well, that was when judges were doing the determination. And I just don't see the relevance to that, logical or otherwise, how that would matter on the narrowing part. They point to Hidalgo, which they brought up multiple times today, which is a dissent. It has no binding authority. It has no effect whatsoever on the case. So they just can't point to anything to say that Hairston doesn't apply today. It does apply today. And the Idaho Supreme Court has rejected that approach. So that's the first reason why this fails. But then even independent of that, there's a second reason. And that is the defense is relying on this narrowing process that has been described by the United States Supreme Court. I believe the most recent case that they've kind of walked through that was the Tulipa case. And in Hall, our Idaho Supreme Court talked about Tulipa and exactly what that test requires. And they were in Hall, they were analyzing a single aggravator because that's how you do this. And it was, the court acknowledged that, yes, this would apply to many, many murders, but it doesn't apply to every murder. And that's all that Tulipa requires. So the way, even if it were appropriate to aggregate all of these circumstances, the appropriate narrowing question is, does it literally apply to every single murder? And even Professor Cover's analysis shows it doesn't. It's a high percentage, but it's not 100%. And so it would pass the narrowing requirements of Tulipa as interpreted by the Idaho Supreme Court, even if it were proper to aggregate these together. Your Honor, in terms of the equal protection claim on geography, I think, you know, here again, they run into a problem with the Idaho Supreme Court. A similar claim based on geography was raised in Hairston, and the court rejected it. The court not only rejected it, the court instructed future defendants, if you want to bring this claim, here's what we're going to need to see. And they said, in order to show that the imposition of the death penalty in Idaho is arbitrary and capricious, there must be some empirical evidence connecting the discrepancy that appears to be shown by Dr. Jensen's study and one or more impermissible factors. And the defense has been aware of that, and instead they bring a study where the person who conducted the study acknowledges, I can't show that. That it's just not sufficient. It's not sufficient to make any kind of, at best, they've shown a statistical discrepancy, and that is not sufficient to claim some kind of constitutional violation, any kind of constitutional violation. I want to end just by talking a little bit about the court's question on, would you have to look at the data up to today? I think the question, or the answer to that has to be yes, absolutely. There's no reason why the date Professor Cover conducted her study has any legal relevance or significance. It would be up through today. And I think this goes back to a problem of this whole accumulating the aggregating factors and then doing a mathematical study and finding a percentage. Because let's say that courts engage in that conduct, and let's say the courts decide it's 50% is the magic number, and if you get above 50%, then your statutory scheme's unconstitutional. Well, what if Idaho is right at 50.5%, so it's unconstitutional, but then over the next year, a bunch of murders are committed and none of them satisfy the aggravating factors. So now we're at 49.5%. Now everyone in that year can be subject to the death penalty because the murderers that committed murders that year decided to do it in a way that didn't satisfy one of the aggravating factors. I don't think there's a logical basis for that. And I think that's why the Idaho Supreme Court has taken the approach they have, where this isn't a quantitative analysis, it's a qualitative one. Is there any narrowing that's being done? And if the answer is yes, then you've passed the test. That keeps things fair and uniform across the state and temporally across time. And so I think that's another reason why it wouldn't make sense to aggregate these. Unless there are any questions, we'd ask the court to.
You want to address the geography issue?
Yes, Your Honor, I addressed it briefly. I'm happy to talk about it more from the Hairston decision.
It's not necessarily a requirement you do, so I just wanted to know, you were fairly summary about it. And it seemed to me the defense had raised some issues that perhaps were a little more expansive than what they had argued in their brief. And so
I would certainly agree with that, Your Honor. So a couple of things on that. First, the idea that it somehow violates equal protection for Idaho to apply the death penalty when other states do not on a national basis. I'm not aware of any case law that would support that. And in fact, it's directly contrary to the case law that we're going to talk about later on evolving standards of decency, where the U.S. Supreme Court has specifically acknowledged that, yes, there are some states that apply it and some states that do not. The conclusion from that isn't that just because there are some states that do not apply it, it's unconstitutional everywhere. So I don't think that that's an appropriate question. In terms of within the state of Idaho, I think to the court's point, with an equal protection analysis, really the first question you have to ask is, who are we talking about and what status do they have or what position do they hold? Because a critical part of the equal protection analysis is you have to treat people that are similarly situated the same. You don't have to treat people who are not similarly situated the same. So that initial determination of are they similarly situated requires a subject, a person. And so to the court's point, I think in the vast majority of cases, at least that I'm aware of, equal protection is raised as an as-applied challenge, as applied to the person bringing the challenge. And so in this case, where they're trying to argue that it's only the larger counties that seek these things, as the court pointed out, that's not true in recent Idaho history. And they, again, have not pointed to any study, Professor Covers or anywhere else, that shows that the reason why there are more death penalty cases brought in the larger counties is because of some unconstitutional reason, rather than, could it be explained by something else, like the fact that they are more appropriate in those areas. And frankly, the common sense understanding would be that you're probably going to see more death penalty cases in more populated areas, because just as a matter of statistics, there's probably going to be more first degree murders committed there, and therefore probably more that are eligible for the death penalty. So certainly they would have to rebut that with some kind of evidence that shows, as the Idaho Supreme Court told them they had to in Hairston, that makes a direct connection between empirical evidence and some impermissible factor. And that's just missing here. Unless the court has any other questions. Thank you, Your Honor.
rebuttal.
Judge, I just wanted to touch on the issue that he raised about Hairston and the timing of that, and the fact that at that time when that came down, judges were doing the imposition of death penalty sentencing. And that really is a very important distinction, because as you know, the arguments that are coming up in other motions, the difference in an experienced judge being able to get into all of these nuanced areas and apply beyond a reasonable doubt in the gateway phase, and then just mercy in the mitigation phase is very, very different than a jury's ability to do those things when it's the only case that they're looking at. So I do think it's important to take into consideration the timing of where we're at now with the jury decision. The other thing is, I just wanted to point out some of that mitigating language that I'd referenced in Tulepa that's in the statute that we don't have. Whether or not the offense was committed while the defendant was under the influence of extreme mental or emotional disturbance. Clearly not something that's in Idaho's aggravating statute to consider. Whether or not the victim was a participant in the defendant's homicidal conduct or consented to the homicidal act. Whether or not the offense was committed under circumstances which the defendant reasonably believed to a moral justification or extenuation for his conduct. A statute that, frankly, those types of terms in our statute would be very welcomed. And I wanted to also point out that the study dates amount to between 75 and 95, those years in Hairston, in 2002 and 2019, for Professor Covers, that's 37 years worth of data with the same definitions. So, instruction in a few more years of data, you've got 37 years to rely on, that there's no narrowing. Thank you.
Do you know what year the Capital Defense Fund was established?
It was after 95. And I think that Hairston may have been the impotence for that. If Mr. Logston was here, he'll be here later. I think he knows the exact year of that. But I don't. I just know it was
Has that
after
mitigated the
95.
issue in your mind?
Pardon?
Has that mitigated the issue in your mind?
No, I think that it has not. It has not. And I frankly think that the new system with the state public defense is going to make it worse. I think that there will be no reason for the state not to charge death in every first degree case, because our statute doesn't prevent them from. Everybody fits. Everybody fits.
Thank you. I will take the issue under advisement and issue a written opinion. It's 10:30. I'm going to take a 10-minute break, and we will adjourn after that.
Hey guys, can you hear me? So, thanks for being here and watching this with me. So it's interesting, we get to see this on other channels other than just the YouTube channel that John Judge had set up. I found out that in Idaho, every court has a YouTube, has their own like channel. They all have, if you go onto the website, you'll see. So when everyone thought it was so odd that John Judge had this channel or whatever, it's not anything unusual. I think that happened after COVID. These courts all got camera systems in place for these types of things. I was just going to answer this question. Nothing's a dumb question in my opinion. So I understand your point, but the reason they're arguing the death penalty now is because they don't want it on the table at all. They want it gone. They want it off the table, period. I think it's an uphill battle just because the death penalty is legal in Idaho. But I respect the fact that they are arguing for for this to be taken off the table completely. So far, I mean, this judge, I think, is much more intellectual and informed and decisive and confident than John Judge, in my opinion. And he is unbiased from what I see. He is grilling both the defense and the prosecution. And that's what judges should do. They really should not be siding with the state just because they are they are employed as a state representative or whatever, however you want to call it. So I like this judge. I think he's fair and he's asking all the right questions. In terms of the death penalty, and I mean, I have a lot to say about the death penalty. I know some of you may have heard me say this or seen a video I made about it, but 1,603 people have been executed by the death penalty since 1973 in our country. And of those 1,603 people, 200 of them were later found to be exonerated of all guilt. So that's 12% of the people that we have executed by the death penalty in our country were later found innocent. And that is really bad, in my opinion, but not surprising, because when you're putting the power to execute someone in the state's hands, in the government's hands, you look at how the government operates to begin with. Our government is not the most efficient. It doesn't operate in the most efficient capacity. And it's not just the government, it's any large, company, organization. You have to be very much willing to make people take accountability and hold them responsible and things like this. And it becomes difficult. And the government's no different. They're not perfect. And so that's why not only on moral grounds do I believe it's wrong, but just in practical grounds do I believe the death penalty is wrong. And in fact, we are one of the only countries left in the world that still employs the death penalty against its citizens. You know, we like to think that we're so civilized over here in America and intellectual and all these other things, but we are one of the few countries left that actually use the death penalty against its own citizens. In addition, you know, the death penalty, when you allow the government to use this, you are, when things are not so great, which lately, in my opinion, they aren't, censorship is at a high point. You know, we're not like England yet, where you get arrested for a Facebook post, but, you know, though things like that can happen, you know, in countries like England, it's happening now. So thank God for the First Amendment. But the point being is that the government can make someone a political enemy and execute them based on that. If you're watching the Richard Allen trial, not that he's a political opponent to the government, but you can see how people are railroaded by the system. Richard Allen is only in, you know, Richard Allen is only in prison right now because he himself came forward and gave some information that he was at the location where the two young girls went missing that day. All right. And now, 5 years after, he gets wrapped up in a murder trial. This is why places, you know, people complain that in lower socioeconomic areas or places where there are a lot of, say, Black people or Native Americans or Latinos, don't come forward and give any information and talk because they know this already. They know that by coming forward and doing something good, like saying I was there, that it can later be used to implicate them. And it has been. This is how the government operates. And I'm not saying that it's nefarious on purpose. I'm just saying that people are fallible. And so I don't believe that the death penalty is ever the right way to go. 12 Gauge asks, well, what's the alternative? Which is a fair question. Well, the only answer I have to that is redemption. The whole point we have a system, a justice system, is supposed to be in place so that we are better. If we are judging other people by their actions and crimes, we are putting ourselves in a place that is higher than them. When you judge someone, you're placing yourself above other people. You're judging people, okay? And so if we are going to do that, we have to be better. We have to act better and with higher moral ground. And so if we in order to do that, we have to believe that people are redeemable. When you give someone the death penalty, you're essentially saying that this person is not redeemable. There's nothing that we can do to rehabilitate this person. They're not redeemable. I don't believe that they should then be allowed to go out on parole. But at the same time, there are ways that the government has ways of brainwashing people with MK Ultra, and that's a fact. It's not a conspiracy theory. So if the government knows psychological techniques to brainwash people into doing horrible things, they probably have some techniques, psychological techniques, not to brainwash, but to help people redeem themselves or at least become better in some capacity and not just throw them away like an animal in a prison cell. So that's my opinion on the death penalty, and I believe in redemption for all people. I don't think that as humans, we are in a place where we should be placing our moral judgment and value on someone else's life, period. And that's just the way I feel about it. And I understand not everybody agrees with that. But when you get 12% of the people who have been killed with the death penalty later exonerated, mostly Black people, Latinos, Native Americans, some white people, but not as many. You know, you have to ask yourself, it's a society that's placing its, you know, prejudices and everything else onto these people. So clearly we are not able to separate our biases in a court of law if these people are being killed, okay, and later exonerated. Clearing their name after they died is in no way, shape, or form going to pay a spiritual debt that you will owe. Spiritual debts are paid, whether people want to believe that or not, in this life or the after. These things take a toll on us as human beings and as, you know, we are not animals. We are divine humans, and divinity is within us. So when we do these things, we are not acting in that capacity, and we'll pay for it in this life or the next. When you think, so what are they arguing today, right? Think about what they're arguing today. What they're arguing today is the aggravating factors. That's why Bryan Kohberger has the death penalty on his, why it's even there. Okay. Because just because you're charged with first degree murder doesn't mean that you're automatically going to be killed. I looked it up. In the state of Idaho since 1973, only 3 people, 3 have been executed. Doesn't mean there aren't more on death row, but there's only 3 that have been executed in the state of Idaho. Okay. So that's not a big number. Where are the most executions in the country? Where do you guys think the state that does the most executions since its inception, where do you think they are? 561 of the executions since 1973 were in Texas. 126 were in Oklahoma. 100, I think, was in Missouri. And then next is Alabama and then Virginia. The majority of executions take place in a very small number of states. And look, I believe in states' rights. Okay. I believe in states' rights wholeheartedly. Even though people are upset about Roe v. Wade, all that happened was the states got the ability to decide and not the federal government. So there isn't a ban on all abortions. It's just a state gets to decide. And the reason why I think states' rights are better is because if you live in a state that you don't like the abortion law or you don't like the death penalty law, it's much easier to go to the legislature, the Senate, your state senator, your state congressman, create a group and go against it. And then guess what? It's going to change. This happens all the time in states. It's so much easier to change a law in a state than it is in the federal government. Federal laws just impose themselves on all of us. And unless we're changing an amendment or something, it becomes much more difficult. So I think that, state laws are good. So these states that execute people are few and far between, but they do a lot of it. And that's because in the state of Texas, they firmly believe in an eye for an eye. I don't believe that way. So I don't want to live in the state of Texas. And that's fair, right? So regardless, the reason why Bryan Kohberger is being charged with death penalty and not just life and parole is because of something called aggravating factors. In the state of Idaho, if you kill someone and you are in the state of Idaho, if you kill someone and you have aggravating factors attached to it, then that is considered, then you are now eligible for the death penalty. So what is the aggravating factor in Bryan Kohberger's case? Do you guys know what it is? I'll tell you, but I'm just curious if anybody knows. Because I didn't know. I had to look all this stuff up, and it's just because this stuff is interesting to me, and I think it's important. The state of Idaho, you have to have an aggravating factor in order to be eligible for the death penalty. So it's actually not that. It's a good guess, but it's actually not that. So the aggravating factors, the defendant has already been convicted of murder in the past. So if someone's been a convicted murderer in the past, that's an aggravating factor. If the person who is being charged is a murderer for hire scenario, so an assassin, say, or that type of thing, okay? If the murder was committed during another serious crime like arson, rape, or robbery. Now, in Bryan Kohberger's case, we know that one of the charges is burglary. And I always thought that was so bizarre in the beginning. What do they mean burglary? Because I take burglary to mean you're robbing someone. If you burglar someone's house, you're robbing them. Breaking and entering to kill someone is also considered burglary. And I think that's kind of a shitty distinction, honestly, because in order to kill the person, you need to be inside of their house to begin with. So this might be part of what they're arguing here. I haven't listened to the finer details and I'm not an attorney, but that may be part of what they're arguing. But the last one is a murder that was quote, especially heinous, atrocious, or cruel, manifesting exceptional depravity. So one of the things about that is we don't really know, at least I don't know, what happened inside that house and what the murder scene looks like. I've heard plenty of people who claim that they know what it looks like, who say this is how, it happened, who say it was, just incredibly atrocious, etc. But I don't know for a fact that that is true. And I don't believe any of us will know, unless somebody has insider information, what that crime scene looked like until it's presented at trial. And then we get reports of it, right? So I would say, though, that when 4 people are killed with a knife, it most definitely would be an atrocious, depraved act. So it's not hard for me to believe that that's what the aggravating factor really is in this case. But they did add burglary, and they did that for a reason, and that's so that he gets the death penalty. Okay. So those are the reasons why he's even on this trajectory of the death penalty. I did a long time ago, actually, when they first used the death penalty for him, I did a deep dive into Idaho and what's going on in terms of why did they pass this law after Bryan Kohberger was charged for a death squad, which, by the way, a firing squad has got to be one of the most terrifying fucking things to think about. Okay. Like, I'm just watching this whole thing. And this is another reason why I think it's absurd. And, you have this man sitting there who is presumed innocent, and all of these people are coming together and convening to discuss if it's okay if we kill him if he's found guilty. And he has to just sit there and listen to this. Just imagine yourself, guilty or not, sitting there while everyone is discussing if you will be executed, if it's okay to execute you once you're found guilty. I think it's absurd. And as human beings, I think we are being absurd to think that we can do this, that we have the power to do this. Okay. That's just the way I think. And I agree, even in cases like Lori Vallow. Okay. I don't believe she should have the death penalty. I don't even know if she's up for it, but I'm just saying. And the other guy, Chad Daybell, who is a piece of shit. I'm just going to say it. I agree. And I don't like to use that term lightly on people, but he is a piece of shit, and so is she, a horrible mother. And I still don't believe that the state should be executing these people. Okay. I can't, and I don't. Now, what happens to them in prison, if something happens and somebody, ends up killing them, that's what happens. Like I said, debts are all paid, but I don't believe the state should be given that ability. So anyway, the legislature in Idaho passed this law for the firing squad. Well, why? Why did they do that? Well, it's because there is a shortage of the pharmaceuticals that are for lethal injection. I'm saying, well, why is there a shortage? That doesn't make any sense. As a medical person, I know there are ways to kill people with insulin. You can inject somebody with insulin and kill them, okay? Make them hypoglycemic. There are so many ways you can kill people with different pharmaceuticals. There should be no shortage. So why is there a shortage? I'll tell you why there's a shortage. And this should tell you a lot, okay? Pharmaceutical companies increasingly have barred executioners from using their drugs, saying they were meant to save lives. One Idaho death row inmate has already had his execution postponed repeatedly because of drug scarcity. Think about that. We all know pharmaceutical companies don't give a flying F about us. Think about the OxyContin fiasco. They could have made OxyContin when they first brought it out not crushable. And so people didn't snort it and then have to go to heroin because they couldn't afford it. Okay. Think about OxyContin. There's so many other drugs I could point to, but I'm just going to point to that one. They knew OxyContin, the developers of OxyContin knew what it would do, and they didn't care. They wanted this. They still made money, and they gladly paid the millions or billions of dollars in the lawsuit after. Why? Because they still made bank on that money. So pharmaceutical companies' level of integrity and moral compass is already in the shitter. Okay. And even pharmaceutical companies have barred executioners from using their drugs, saying they were meant to save lives. Okay. So think about it. A pharmaceutical company doesn't want to give a state the means to execute someone. They don't feel okay with it. Okay. If a pharmaceutical company doesn't feel okay with it and feels like it's unethical, we got problems. Okay. We got problems. In the state of Idaho, I did a little show on this a long time ago too, but basically they were meeting in alleys with suitcases like crack deals, getting these pharmaceuticals, okay, to execute people. And they've only executed 3, but they were having a hard time. This was probably for Thomas Creech. And look what happened to him. What happened to Thomas Creech? If any of you have small veins and you've gone to the emergency department, or you've had to get your blood drawn and you just have those roly-poly veins or deep veins and they can't get it. You know how uncomfortable it is when they go digging around to get your vein. Well, that's what happened with Thomas Creech. They had people looking for a vein on this man and they couldn't find it. They could not find it, digging around for a vein. Well, you passed the firing squad. Why didn't they use that? Because they know it's fucked up. That's why. Okay. So now they have to decide if they want to do deeper veins, like if they want to go into the carotid or not. You know, like when people get central lines in the ER because you can't find a little vein. Now they're trying to figure that out. Does this not sound absurd to anyone? Regardless, Thomas Creech's botched execution, and that's cruel and unusual punishment, period. Okay, period. It shouldn't be done. Even I think a federal judge barred them from trying it again at this point. Okay, are we so bloodthirsty that we need to do this to people? I don't understand. On top of which, the amount of money, even if you don't want to think of it from a moral standpoint, the amount of money it takes to keep someone on death row is absolutely insane. If you're going to say we should just kill them because they're irredeemable and we can't rehabilitate them and they're garbage human beings because we're positive that they did something horrible, right? No matter what, if someone is put on death row, it is years and years and years before it ever happens because of the appeals. Okay. So if you want to say, well, we just don't want to feed them. Most of these people aren't executed for decades. And the amount of money that is spent keeping them out of being killed, okay, is so much more. So it doesn't even make sense from an economic standpoint to have death as an option. Okay. Sociopaths and people who truly have, just no empathy, no feeling, etc. I don't know that the death penalty is a deterrent. And that's the only other argument, that it's a deterrent for people, the death penalty. Well, if you keep them in prison for the rest of their life and you try to rehabilitate and redeem them, not to release back in society, but just to recognize that this is another human being, I think it's just a better way to do it. Okay, they're coming back here.
All right, I think we are on now the motion to strike the individual statutory aggravators. I will give each side 25 minutes and you can address them in whatever proportion you like within that.
Okay, Judge, I will be covering heinous, atrocious, and cruel utter disregard, and then I will do multi-murders, and Ms. Taylor will do future dangerous. So I'll basically do the next 3, and given the time that you've asked, I'm assuming there will be less questions.
I will try to restrain my curiosity.
Right. I'm happy to engage with you.
If I, and I, as you know, I gave you some additional time, and that was why.
Right. Thank you. We are asking that the court strike the aggravator, especially heinous, atrocious, and cruel, manifesting extreme depravity. And I want to focus, I think I just want to start really focused on how this is different than Hall. You know, we're aware that Hall, Arabay versus Levitt, there's a lot of discussion about having addressed this aggravator before. We are framing it for you in our argument in a different way. And so what I want to show are the distinctions is that, you know, Hall was a decision was issued in 2018. So was Hidalgo. So when Hall issued their decision, the arguments hadn't been framed in light of what we just argued about Hidalgo and that eligibility narrow. One of the cruxes of this argument is that what the Idaho Supreme Court and the Idaho courts do with this aggravator is they've created a jury instruction that is construction, also known as, and called in our briefing, judicial gloss. Our argument is that Osborne is from 1981. That's when the judicial gloss was applied, and then recently the Idaho Supreme Court adopted and adopted instructions related to this. But what happened in 2011 is that the Idaho Supreme Court issued the Verska versus St. Alphonsus decision, and in that decision, the court said, this court has consistently adhered to the primary canon of statutory construction that where the language of the statute is unambiguous, the clear expressed intent of the legislature must be given effect, and there is no occasion for construction. And the courts have not taken that into consideration. So if the statute is unambiguous, then it should be given its direct meaning, which we quoted in our brief, would be heinous means utterly odious or wicked, atrocious means horrifying, wicked, and cruel means willfully causing pain or suffering to others or feeling no concern about it. And if it is ambiguous, then under Verska, the judicial gloss should not be allowed.
If it is ambiguous?
If it's unambiguous, then the judicial gloss should not be allowed. But what, you know, the state is arguing that it is, has not argued that it's an ambiguous statute, because that would give us grounds for the argument that it should be stricken from as an aggravator as arbitrary and capricious. And so we are asking that you take into consideration the way that we are framing this argument, which is different than it was
Between
in Hall.
ambiguous and vague.
Pardon?
Difference between ambiguous and vague.
I don't know that I can necessarily draw a distinction there. I think that they're, you know, similar. Yeah.
Well, so let's do all of yours, and then we'll do all of theirs. I think it goes faster that way. If we do this back and forth, I think it takes longer. They can take notes.
So utter disregard falls under the same argument. The one thing that I want to point out about utter disregard is that Idaho is the only state that has that as an aggravator. But when you look at other states, there's language that is found that is the same as heinous, atrocious, and cruel, which is interesting because it looks like almost we have the same aggravator labeled as two different things. And we also raise the argument there that it's a separation of powers violation when there is construction on that statute, and that violates Verska. The next one that I am going to cover is the multi-victims aggravator. Idaho is the only state that has both a multi-victim and propensity aggravator. A multi-victim aggravator is clear. We were having that discussion between clear and fuzzy. Multi-aggravator is clear, 1 + 1 equals 2. The irony in some of that is that it seems to lessen the value of a single human life, but it still doesn't tell us anything about the culpability of the person who has been charged with the crime.
Or isn't it more culpable to kill 2 people than 1?
I think that the issue is, the problem is that it is,
Isn't it a morally more problematic, the number of lives you take?
I think that it depends on, first of all, I want to start answering that question by saying any life taken,
I agree, and
right?
right, and the
but-
floor is pretty high, but what I'm saying, doesn't that bring you above the floor?
I think that it depends on the underlying facts of what is the result, what's the basis of how multiple occurs. And so just to say that the number of people relates to culpability, I think that what the argument that we're making is that supports the other aggravator of propensity. And under Idaho's the method of selection with a jury and the rules about double counting, while the jury can take into consideration the same facts for multiple aggravators, there must be more than one fact per aggravator so that there's not double counting. And that is the problem when you've got a multi victim aggravator and you also have a propensity aggravator. And there's been, as we cited,
Is that a constitutional problem or an evidence problem?
it becomes a Eighth Amendment constitutional problem when a jury has an inability to properly distinguish between those issues in finding aggravators beyond a reasonable doubt.
I mean, as the gatekeeper, I assume that if the state hasn't provided additional evidence that would support propensity that is not included within the multiple murders, then that aggravator wouldn't go to the jury, right?
Well, I mean, we would hope that the gatekeeper would do that. Yes, Judge, we're asking you to be the gatekeeper now and prevent us from even getting to that question because of the problem that is identified. And we provided the court with law review articles where the issue has been studied about how impactful multi-victim facts are into the ultimate decision regarding aggravators. I also wanted to point out that there are multiple states with a multiple out of aggravate that have that multi-aggravator, but they don't have future dangerousness, which Ms. Taylor will talk about, and that is very related to propensity. And those states are Alabama, California, Kansas, Montana, Tennessee, and Utah. And in fact, Texas is a good example of, it's a part of the definition of capital crime, and then the jury has to decide on the aggravator of propensity after that has been included as part of the narrowing in the Texas statute. So for those reasons, we'd ask that you strike the multiple aggravator as well.
Your Honor, we're asking the court to strike the aggravator of future dangerousness or propensity, whichever label we want to put on it, but it's found in subsection I of 1925-19, subsection 9. And I think when we're thinking about the constitutional way this is laid out to be protective of the Eighth Amendment, to have a true narrowing, and it can't be vague. We've been talking about that all day, so I won't go into that again. But with that in mind, I want to read the words of this aggravator for the court. That the defendant, by his conduct, whether such conduct was before, during, or after the commission of the murder at hand, has exhibited a propensity to commit murder, which will probably constitute a continuing threat to society. That language does nothing to narrow. I'll skip right to the vague part of the argument. We're asking the court to consider three things in striking this aggravator. It isn't narrow. It's very vague, and it doesn't go to the culpability of the crime that's been charged and, if this happens, convicted of. Your Honor, this language, I think, has been acknowledged by our Idaho Supreme Court as needing the gloss in Creech. And I would say that what's required is that the statute, which Idaho doesn't have, has to provide the narrowing or the sentencing structure, and those things are legislative processes. And that hasn't happened. We have the gloss from the Supreme Court. The gloss that the Supreme Court has put on this, though, does not do anything but loop us back to the statutes that define murder and then exclude voluntary manslaughter. If truly we are to have an aggravator that selects out the worst of people who have been convicted of murder, this does not do that. The language in this aggravator is incredibly vague. When you think about really what is going to happen in front of a jury, they're going to get all this evidence that is supposed to be proven beyond a reasonable doubt. I trust the court will instruct them on that. But then they get this evidence that probably will make them believe that person's a future danger. The chance for a jury to misunderstand the call and the burden that needs to happen is really great by the language alone. And Creech really doesn't do anything to help. The gloss that gets put on, the jury instruction that gets put on, that doesn't help. That just says
Didn't
people.
Hall say that it was okay? I can't remember if they addressed that in Hall.
I think Hall did say it was okay.
So what am I to do about that?
You are to listen to that, allow me to make my record, which I am, but you were to say nobody else has talked to me about the real language in here when it says probably. That is confusing to a jury. This isn't a judge's call any longer, but this is confusing to a jury to have those words in there. And the chance to find this aggravator, either based on one of the other aggravators, which we know cannot happen, or at a lesser burden because of the word probably, you're to find that is way too vague. And you should strike this aggravator because of that. Additionally, while we're talking about vague, there's a lot of potential for the jury to misuse mitigating factors and make them into future dangerousness aggravators. And I
Isn't
think
that the truth, the possibility always in sentencing? I mean, one man's aggravator is another man's mitigator. And I think you pointed it out well in your brief of mental health, right? But isn't that the nature of individualized sentencing and the consideration of those factors?
I think it is a danger. And I can't square in my mind how I am to do my ethical duty to my client and to abide by the guidelines that are set forth in capital cases and do an investigation into mental health and then turn it over like Idaho says I must, and then subject my client to the state's expert to grill him for however long. I mean, I have this duty. My client has the right to present this, but now I have to do all of this and give all of that information up so the state can use it in an aggravator that says, just tell me that the person will probably be dangerous in the future. That is just terrible, Judge. And for that reason alone, you should strike this aggravator. The last comment I'll make is that future dangerousness doesn't go to the conduct, the culpability of the conduct that has happened. And that's really what these aggravators need to do to narrow properly the scope of who's who.
I can't tell you the number of times I've sat in court and listened to a prosecutor talk about at sentencing that my client or my client's acts are the worst they've ever seen. And that can't be true when you sit in court day after day after day and you hear that about person after person after person. This statute doesn't do anything to help a jury decide who's the worst of the worst. This aggravator absolutely has to be struck. It's a violation of the Eighth Amendment.
Thank you.
Your Honor, beginning with the heinous and atrocious and cruel, this aggravator specifically has been upheld by the Idaho Supreme Court, and specifically the judicial gloss placed on this aggravator in Osborne.
Was
Now-
all a jury determination? Do you know?
I'm not sure on that, Your Honor, off the top of my head. I apologize.
I think it was, but I don't recall specifically. Notwithstanding the fact that I think that I'm the actual judge on the case now, I don't recall it because that issue hasn't come up. But
Thank you, Your Honor. And I apologize. The defendant has raised this argument that in Verska, the Idaho Supreme Court's decision stating that the court would not rewrite or void an unambiguous statute is essentially the same thing as stating that the Idaho Supreme Court is saying that we can't put a gloss on a statute. But those two things are very different, because placing a gloss on a statute to ensure its constitutionality is not the same as rewriting or voiding a statute. If Verska is taken to that extreme, then courts can't interpret statutes at all. And that's not the holding of Verska. Verska simply stood for the proposition that the court was declining to rewrite or void a statute. And of course, the Idaho Supreme Court has never rewritten the heinous, atrocious, and cruel aggravator or the utter disregard aggravator or any of these aggravators. They've simply placed a judicial clause. As to the future dangerousness and propensity one, which was the most recently addressed, that too has been upheld by the Idaho Supreme Court in State versus Creech. The propriety of considering future dangerousness has been upheld by the United States Supreme Court in Geographic versus Texas. In their propensity argument, their future dangerous argument, the defendant is essentially asking this court to start with a proposition that a jury is not going to be able to follow the court's instructions. And of course, we can't start with that proposition because juries are presumed under Idaho law to follow the instructions that they're given. And that is another issue. That issue is also true in the defense's multiple victims argument. Their argument with multiple victims really doesn't cite to any case law. It's simply based on the fact that they're assuming that a jury is unable to distinguish between propensity and multiple victims. And again, the court is being asked to start with the presumption that a jury won't be able to follow the law. And that's contrary to the state of the law. We can't presume that because juries are presumed to follow the law. Additionally, we also can't start with the presumption that the state is going to just put on the same evidence for all these aggravators. The court should also assume that the state will put on independent bases for each of these aggravators during the penalty phase. That's our legal obligation. And the jury will be instructed as to what the law is. They will be instructed that they can't double weigh or double count. That's very clear in the case law. The state would just ask that the court decline to presume that the state will present the evidence in a way that's contrary to law and that the jurors then won't follow the instructions. That can't be, Your Honor. So The state would ask the court to deny the defendant's motion as to these aggravators. All of the aggravators all of these aggravators have been upheld, specifically the hack along with utter disregard and future dangerousness. There is case law directly on point that is binding on this court. We would ask the court to deny their motion.
Thank you.
Judge, to answer your question about Hall, Hall was originally sentenced by a judge, and then the sentencing was retried, and Mr. Chastain and Ms. Christensen handled that case.
My memory came back to me between then and now, so thank you for clarifying that.
I want to point out that Verska says, if it's socially or economically unsound, the power to correct is the legislature's, not the judiciary's. If it needs fixed with construction, as we argue that it does, it must be stricken. And I want to address the question that you asked about why not wait until the evidence comes in and I can strike the aggravator at that time. It goes to the point of why we are arguing all of these right now. There's a huge difference between picking a death qualified jury and a non-capital qualified jury.
But that just went to my point of your argument presumes I would strike all of them. If, for example, I were just looking at multiple murders versus propensity, and those two so overlap that you can't have both. You could still have one, or you could have both. But if there's not evidence independent of one, then you would strike the one.
So you're correct that we are asking you to strike all of them so that we don't have to pick a death qualified jury, because death qualified juries are highly likely to convict in the guilt innocence phase. So we are very, very concerned about that, and the fact that that is so different in a death penalty case. But to the extent that you might strike some and save one, for example, the multi aggravator, there's a vast difference in what happens in front of the jury in the selection phase with that aggravator versus the others that we are asking you to strike. Thank you.
Thank you.
Your Honor, I certainly didn't mean to tell the court that I would presume whatever jury we end up with won't follow the law. What I'm saying is that that particular statute, the future dangerousness statute, is really tricky. It's tricky because of the use of the word probably. It's tricky with the rest of the wording too, and based on the information that will likely come in. I point out that when it was up to a judge to decide, I think a judge is well versed in what does beyond a reasonable doubt mean and what is a probability. The court looks at that all day, every day, and those are hard concepts for a judge.
Standard would be that the jury would have to be convinced beyond a reasonable doubt that it is probable that the defendant would be likely, or it's probable that they would kill again. I think is the way that washes out.
I think that's the way it washes out too. And I think it's just a problem with the word probably in there. So when a judge was doing this, it was less of a problem, but I still think there's issues with that particular aggravator. And I would point out that the higher courts in Idaho have recognized the problem. That's why the decision in Creech put a gloss on it. And I think when the courts recognize that that's a problem and there needs to be a gloss or a fix put to it, that's one thing for the court to consider. How the fix was done, I think, is a problem. It's a jury instruction, not by the legislature. But keep in mind, there's a problem with this instruction or with this aggravator. It needs to be fixed, but the fix is to loop back to statutes that already exist. And I don't really think that's a fix. And I'll stop there.
All right, I think the non-statutory aggravators is the next issue for our attention. So with that, I'll hear from defense.
Thank you, Judge. Your Honor, by way of housekeeping with the non-statutory aggravators, I understood the state's response briefing to say that they agree that they have to provide notice and any discovery about non-statutory aggravators as well.
They said that they would, is what they had said they would.
Yes. So I think I don't have to argue about that. I think I'm limited to arguing about the burden of proof required for non-statutory aggravators.
Arguing for the defense, for the state on that issue.
Yeah, Your Honor, the state's position is that the statute clearly says that Rule 16 applies. We agree Rule 16 applies and we'll comply with Rule 16.
I'll limit my comments then to burden of proof. Your Honor, our position is that non-statutory aggravators need to be proven beyond a reasonable doubt as well. We know that the state can use non-statutory aggravators to help them establish aggravators beyond a reasonable doubt. And looking at the court's new jury instructions that just came out, beyond a reasonable doubt is all over those. When we're talking about aggravators, there's no question there. Those jury instructions are silent on non-statutory aggravators. So I can't lean on those to say that the court should find that these have to be proven beyond a reasonable doubt. But from a fairness standpoint and from a it just makes sense standpoint, you should say they have to be proven beyond a reasonable doubt. I'm thinking about this in the context of having a jury and having the prosecutor producing evidence and arguing beyond a reasonable doubt, but having these other non-statutory aggravators and say, these are things that we have that you should consider, but we don't have to prove these to you beyond a reasonable doubt. I think there's a real danger in a lack of confidence in the finding of an aggravator if you don't require them to prove the non-statutory aggravators beyond a reasonable doubt, just like their statutory aggravators. Capital cases are a really big deal. And if we're going to get all the way to the end of this, and that's where we're at, the court has to have confidence in what's presented to the jury. Mr. Kohberger has a right, if that's where we end up in his case, to have a jury finding any single aggravator they might find beyond a reasonable doubt. And we think you should order the state to meet that burden if they're going to present non-statutory aggravators.
Thank you, Your Honor. I want to start by just, I tried to be very careful in my brief to refer to it as non-statutory aggravating evidence, because I'm not sure what a non-statutory aggravator is. I want to be clear, the state's under no impression that there's some shadow list of aggravators that it can prove one of those and that qualifies the defendant for the death penalty. We are, of course, required to prove beyond a reasonable doubt one of the statutory aggravators. And I think what we're talking about here is just non-statutory aggravating evidence. So evidence that may not be, and if I'm being...
So if you look at it like a scale, right? And defense puts on evidence of mitigation, and the state has to put on at a minimum evidence beyond a reasonable doubt of a statutory aggravating evidence. When you go to weigh, does your non-statutory aggravating evidence go on the scale when that weighing is done?
Yes, Your Honor. And I think that that's clear from the Hall decision when they talked about this. They talked about they talked about the Zant decision from the United States Supreme Court and how it's important that juries understand when they're making that, when we get to the individualized determination of is death appropriate in this case, it's important that the jury have a wide array of information. That's the purpose of the statute, is what the Idaho Supreme Court said. So yes, I think at that point, any aggravating evidence that has been presented goes on that scale. Now, to be candid with the court, in my mind, anything that's relevant to a statutory aggravating factor isn't non-statutory aggravating evidence because it's relevant to the aggravating factor. And just to be frank, I can't even come up with a good example of what the state would put on in this case that would qualify as not relevant to an aggravating circumstance, but relevant to the overall weighing process. I guess my point is I don't know that this is going to be an issue, given that we will, of course, comply with discovery. We will provide everything that they'll know what we're going to say before we say it. And if there's an issue, we can raise it at that time and discuss, is this actually relevant to a statutory aggravator or not? And if not, does it fit into what I consider to be a very narrow category of non-statutory aggravating evidence that is still somehow relevant to the overall decision, but not one of the
I
aggravators?
think the visual using my scale would be to get on the scale, the statutory aggravating uh, evidence would have to have been proven beyond a reasonable doubt, right? That is, you have the existence of that aggravator would have to have been proven beyond a reasonable doubt. As I understand the non-statutory aggravating evidence, the existence of that evidence would need to be proven only by a preponderance of the evidence. Is that your understanding?
You know, I don't know that I would completely agree with that, because I don't know that that's laid out in the instructions that it's to any specific burden. I think if you look at the jury instruction 1722 on jury deliberation, it talks about finding the statutory aggravator beyond a reasonable doubt. And then when it gets to weighing, what it says is you must each decide for yourself whether all mitigating factors presented, when weighed against each statutory aggravating circumstance proven by the state, are sufficiently compelling to make the imposition of the death penalty unjust. You do not have to unanimously agree upon what mitigating circumstances exist. The existence of mitigating factors need not be proven beyond a reasonable doubt. You must each decide for yourself whether mitigating circumstances exist, and if so, then consider them in your individual weighing process.
Right, those are the mitigating.
Correct, but I think what I'm getting at is that's what we have in terms of the instructions of this weighing. Is it's saying to the jurors, you're going to conduct kind of an individual weighing process to decide whether it's just or unjust in this circumstance. And that's the point where these things would come on the scale, to use your analogy. And so I just don't know that there's a point where you would instruct the jury, you know, you heard from witness X, they said A, B, and C. You can only consider that if you find that A, B, and C is true beyond a reasonable doubt. I don't see an instruction for that anywhere. I don't think that's typically how you do sentencing. You know, they would put on their mitigation. Maybe we have some rebuttal to that mitigation that you might consider non-statutory aggravating. But then again, it specifically tells the jury you do not have to find mitigating beyond a reasonable doubt. So my point is, both in the mitigating evidence and in this non-statutory aggravating evidence, there isn't a standard that's given to the jury. And I think that is what was intended by the instructions. And we could debate whether that's the right call or not, but I think that's what the statute calls for. I think that's what the instructions call for. And I think that that's the process that we should follow. Recognizing, of course, this court's role as a gatekeeper as to what gets heard at all. The fact that we'll be complying with the rules of discovery and they can bring up any objections that they want beforehand. I don't know that that this will be an issue in the case. Unless there are any other questions, we would ask that you deny the motion. Thank you, Your Honor.
Your Honor, I would start by saying I thought I heard the state get really close to saying they're not planning to produce any non-statutory aggravators or non-statutory aggravating evidence, whichever way you want to talk about that, which might be really good. It might save the court having to make the decision if they get all the way there. I would say, though, there's not a statutory list of non-statutory aggravators, but in Hall, that decision talked about things in a person's background, if they had a prior criminal history, things about their character. And a prior criminal history, that's fairly definitive. Either you have one or you don't, right? But things about a person's background, that's where it gets really questionable. Are we talking about people's opinions, people that maybe would have an axe to bear with the person that they're talking about? So I think that when you consider what Hall talked about as a non-statutory aggravator, it becomes really important that the state have the burden of proof of beyond a reasonable doubt for those. I would just close by saying that Gardner versus Florida talked about why we have notice and that reliability matters. but it's the same thing on this kind of information, this kind of evidence, these kind of non-statutory aggravators that get produced. It has to be reliable, and the court has to be able to rely on what a jury comes up with. And Mr. Kohberger has a right to have information come in fairly, to have notice of that information, and for the state to carry the burden. And they need to carry the burden if they want to present non-statutory aggravating evidence. Thank you.
Thank you. All right. You're okay with it. I'm going to swap 8 and 9, just because I could see 8 potentially going a little bit longer than 9. And so, well,
Your Honor, can I
Yeah.
help on that?
yeah,
If the court takes the first part of 9, the speedy trial issue, that's the one I'm handling. And I think we've got Jay that's ready on the rest of them. We can cover it, but he's really close.
so he's not here. All right. Well, let's start then with 8, contemporary standards of decency.
That's the one that Mr. Logston
Oh, he
would
is.
be here. I've got Speedy.
Would you have, who has trifurcation?
Jay is the one that's the most prepared on trifurcation.
So you've got Speedy. Let's start with that then.
I can do that. Thank you, Judge. Your Honor, we're asking the court to strike the death penalty in this case based on a conflict of constitutional rights and Mr. Kohberger having to face the choice between holding on to one constitutional right at the expense of another. And that's what's happened here. He has had to choose between his 2 constitutional rights, and those were effective assistance of counsel or speedy trial. Mr. Logston wrote the brief on this, and he did a really good job with the history and why we should look at Idaho's speedy trial, constitutional guarantees of speedy trial in the same time frame that the statute 1935-01 says. I'm not going to go into all of that again, because really this is about the choice of picking between constitutional rights.
It seems to not to go into the history that your argument essentially asks the court to equate what the pre-constitutional statutory standards were as then constitutional standards. And I think the court has said that that's not the case. Am I wrong about that?
I'm not sure I'm following what the court's asking me. I'm
So
sorry.
it seems that you're asking the court to equate what the statute said about speedy rights before the Constitution, Idaho Constitution provided for it, and treat that as the constitutional standard and grafting it into the constitutional standard.
I would say that it's there to provide guidance, because there was the statute we have now is after the Constitution. The territorial statutes were before we had the Constitution. And when Idaho wrote its Constitution and said, we guarantee defendants a right to a speedy trial, there was that already in mind. I don't think our Constitution says it's 6 months to the day and it's over after that. I don't think that at all. But I think that what was a speedy trial would have influenced a speedy trial right. I do not think our Constitution says it has to be 6 months, but I think our statute does now, and our statute derived from an older statute. And I think that statute, well, I know that statute predated our Constitution, and I think it influenced the writers of the Constitution to, as a guideline, as a limit. We also know that speedy trial you can go beyond the statutory time frame, and you can stretch that out in different circumstances for different reasons. And our argument is less about that. That's not the argument. The argument is the choice that Mr. Kohberger faced in August of 2023, when he had to choose to continue his case, thereby giving up his speedy trial rights, or go to trial on October 2nd of 2023, 10 months after being charged with this case, with completely unprepared counsel. And that's really the crux of this argument. And the remedy is for the court to strike the death penalty because Mr. Kohberger had to choose between rights, reinstate Speedy, and reset a sooner trial date. That's the remedy. I want to talk about what happened and why Mr. Kohberger had to continue his case. The court's already heard a little bit today about the duties of counsel in a capital case and the kinds of investigations we must launch immediately. It's not just about the facts of the case, but it's also about the facts of the case. But the mitigation phase has to be launched whether or not you ever end up with a conviction. That work has to be done. That's the way it works, and it takes the time to do that. You have to find experts, you have to find records, and it takes time to do those things as well. So, and discovery can be a really big deal, and I think the court is probably starting to understand just how big of a deal that is. Last August of 2023, when we were in that place where we had to make that decision, and there was a scheduling order from the prior court in this case that told us you have to continue it by this deadline, by this date, or you can't continue it and you're just going to go to trial. So I think we're positioned a little bit differently when we are truly in a place we have to give up one right to have another right. Had Mr. Kohberger gone to trial and stood on that right, his speedy trial right, and lost his right to effective assistance of counsel, there would have been more than a year's worth of discovery that his counsel would have not been able to know about. We have continued to get discovery. I think there's a bit more that continues to trickle in even past the deadline. I'm not arguing about that right now, but it's just a vast amount of information that Mr. Kohberger would have not had counsel prepared for. We do not have a mitigation investigation completed. We're in process with that still, a year and 2 months after that deadline. So he would not have had that to benefit him either. I think one of the most important things the court should think about when we think about Mr. Kohberger having to choose between his constitutional rights is that we're here right now because he couldn't get a fair jury in Latah County. And if we'd gone to trial in October of 2023, he would have maybe held on to his speedy trial rights. Well, he would have held on to his speedy trial rights, but he would have given up his right to effective assistance of counsel and his right to a fair and impartial jury.
What's wrong with the idea of speedy evolving on a sort of good cause basis? I mean, capital cases at the time the Constitution was adopted were tried within 6 months, right? The standards of how to try those cases were obviously different, and as more contemporary thoughts about that have arisen, it's become the standard that they require more. And so why wouldn't Speedy be flexible to accommodate that?
Well, I don't know why it would or why it wouldn't, but that's not been what's happened. We don't have a separate criminal rule that says that. We don't have a separate statute that says that. We would bend the Idaho Constitution until it breaks to make it say that. I'll give you kind of an example. During the time of COVID, when the Supreme Court told the speedy trial rights, it did that based on a national emergency. Court orders were issued. I am not saying whether I agree or disagree with that, but that's something that happened. And I think one of the cases the state cited in its response brief, State versus Ish, I think that particular case had 422 days of time between when the remitter was issued and when the case went to trial. And that person asserted their speedy trial rights that whole time. That happened during COVID when the court had its emergency orders during that whole time. So I think to say, well, it's a capital case and they're a lot different than they used to be, and they are, and they're a lot of work and they take a lot of time and investment. They do. But there's nothing that's been changed in our constitution, in a court rule, in a statute to say if it's a capital case, speedy trial, really, you just don't have that right. A person facing the death penalty just doesn't have that right now. And Mr. Kohberger had to choose between those rights. And I think the court can and should strike the death penalty in this case based on the
Well,
record
that would
here.
result in the death penalty being struck in every case.
Your Honor, if that's the way it is, because our clients collectively in the state of Idaho, when you have a capital client, if that's the case, then that's the case. I mean, we have been
The
doing,
Constitution is flexible enough for the Supreme Court to itself say, well, we can pause that right. And we can expand that right based upon the circumstances, i.e. COVID. Why can't it expand the time that speedy is measured by constitutionally, given that evolving standards have required more time to present a capital case and measure it against that?
I would say that I don't know whether they can or they can't, but they have not. And that's the critical area. I would say the Supreme Court probably would believe it could do that, but it has not done it. And I would say they would believe that they could because they did so during COVID. But that hasn't happened. That has not happened.
So you think that the Supreme Court would likely say, well, as opposed to interpreting the constitutional right more broadly to apply over the more flexible, given how the defense of capital cases have evolved, they would be more likely to say, well, we're just going to not have any capital cases, period.
I don't know if they'd say that or not,
Well, that's what
but
you're asking me to say.
I'm asking you to say that. I'm asking you to
My
do
job as a
what,
district judge, if there's not an issue that has been decided by the court, is determine how that court would decide things.
well, I think you can consider what Judge Boyce did in the Vallow case. And that had to do with discovery that counsel didn't have enough time to review and to prepare for, and it would have disadvantaged the client. And so Judge Boyce in that case struck the death penalty.
That was as a result of the state having failed to provide the information, violating its court order. And then the remedies were, well, do we push trial back or not? And the choice that Judge Boyce gave the defendant was, well, we can go to trial, but I'll remove the death penalty because a lot of the discovery related to that. Or we can continue the trial for you to review that. But so you can either go to trial with the death penalty, without the death penalty now, or you can expand it with the death penalty. One defendant chose one and the other defendant chose the other. But in this case, the decision to waive speedy was not as a result of, as I understand it, a violation of a court order by the state.
It was as a result of a court order. And when we waived speedy, we advised the court and counsel that this motion this day was coming. We don't think it's appropriate to force somebody to choose between competing constitutional rights. Lori Vallow had not ever waived speedy trial. And so she had the choice to waive speedy or not face the death penalty. And we think that since we were forced to choose between rights, those should be reinstated and the court should strike the death penalty.
Thank you.
Thank Your Honor. So not only can the Idaho Supreme Court do that, it's already done it. The Idaho Supreme Court has said that we interpret Idaho's Constitution for speedy trial the same way that the federal Constitution is interpreted under Barker. There's one exception that has no application here. And so it's an individualized test based on 4 factors, and you're really looking at kind of the overall reasonableness of the delay. I would direct the court specifically to the Langford case that just came out last year. The Idaho Supreme Court walked through the difference between the 2 constitutions, explained how they operate, and then found specifically in that case that they charted out how many delays they were, what the delay was for, who caused the delay, and then was it reasonable or not. And they found, they said, in sum, most of the delays here were precipitated by Langford's own actions. In the case of the last and longest continuance, the delay was reasonably necessary to allow new prosecutors and new defense counsel time to prepare for trial. So they found that's a reasonable, under the Constitution, that is a reasonable delay. So there is no choice here. You don't have to choose between speedy trial or effective assistance of counsel. You can have both. I think what the defense is saying is they've lost their statutory right to 6 months, which they do lose if they take an action to delay the trial at all. But that's not a constitutional problem that they have to give that up if they want to maintain their constitutional right to effective assistance of counsel. Now, in this case,
Well, and that was my point in perhaps not well stated, is that it seems what this defense is trying to do, and perhaps you can comment on whether I'm saying this correctly, is to engraft what was the territorial law, which is that a case had to go to trial within the, at that time, courts were held in sessions, calendar sessions, right? I think there were 2 sessions a year or something like that. That was the speedy right. And then we had the Constitution that doesn't, necessarily give us such a fixed time frame. But the argument is, well, because that was the territorial law at the time, therefore that's the constitutional right. And it is engrafting that statutory construct to mean the constitutional right.
potentially, Your Honor, though I'm not sure that's exactly, because my understanding of the pre-Constitution statute was that it was based on kind of the circuits and when they came, and we don't do that anymore. And so that time frame just doesn't make sense today. You wouldn't be able to just engraft that in the Constitution and apply it today, because
Well, my point is that's, I think, what this defense is arguing essentially.
yes, Your Honor, but the statutory right they're pointing to comes from the new statute that was passed in 1980 that gives the 6 months. Time period, and regardless of whether they want,
Argument that the 6 month is functionally equivalent of the twice a year circuit.
if that is the argument, I don't think that it gets past the Idaho Supreme Court has said no, it's not. So under the Idaho Constitution, we use the Barker test. The crux of the matter here is that the defendant didn't have to waive his constitutional right to a speedy trial. He did so under advice. He did so in writing. He did so knowingly, but he didn't have to. The trial could have been continued, even at his own request, without him waiving that right. He waives it statutorily by moving for a continuance or to ask for more time to prepare, but he does not waive it constitutionally. If he did, then most of this Langford analysis would have been completely unnecessary. But instead, at the end of the day, when you do finally get to trial, the reviewing court looks back and breaks out segments of time and says, whose fault was that delay? And as the court said in Langford, many of the delays were because of Langford, and so they don't count against the state. But the court easily could have said, well, he asked for a delay, so his constitutional right was waived. They didn't, because that's not how it operates. So the real problem here, I think that the defense is grasping with, is that they didn't need to waive his constitutional right, but they did. So, there's not much the state can say other than that wasn't required. The Constitution not only can be flexible, the Idaho Supreme Court has held that it is in fact flexible. And one of the reasonable, a proper reason for delay is to prepare for trial. And that means this is not a choice that has to be made by any defendant. It didn't have to be made by this defendant, but he chose to. Unless there are any further questions. Thanks.
Just briefly, Judge, we're not trying to graft in a time into the Idaho Constitution. We're looking at the word, the guarantee for a speedy trial, and trying to figure out what the word speedy means. And so
Well, isn't speedy mean the Barker test?
at the time the Constitution was written, I don't think it did.
Isn't that what the Supreme Court has said it means?
I think our Supreme Court does agree that it's the Barker
Again,
test.
I think I probably can dispose of a number of motions by simply saying that the defense asks me to do X. Doing X would violate the binding precedent of the court. Denied.
I think if I was here saying dismiss the case based on a speedy trial violation, I think that's exactly what the court would do. This is a little bit different. We're asking for the court to set the case back to the point where we had to choose between constitutional rights and to strike the death penalty. In our case, this is the last point I'll make. In our case, we signed a waiver of speedy trial, and it was a form, I believe, that was generated by the court. It was signed on August 23rd, 2023. Mr. Kohberger signed it, and I assigned, with the parentheses, attorney for the defendant. And in that form, and remember, our scheduling order said you have to do it by this day, or you don't get a continuance, you just go into trial. We gave up the right to, under the United States Constitution and the Idaho Constitution. And I have a printed copy, but I know the court probably has the entire court file. That's it.
All right. That, along with the other motions that will be taken under advisement. Let's take a lunch break. It's 5 to 12. Adjourn at 1 o'clock. Thank you.
All right.
Hello, everyone. What's going on over here? Long time here. Let me put this up here. I'm a long-time true crime follower, but never realized how naive I was about the law until this case. Thanks for answering all my questions. John Judge was not a good representative. Yeah, no, I agree. And listen, I'm not like an authority by any means, and I appreciate you saying this. I really do, because I'm learning just like everybody else. And so when I do answer the questions, I only do it if I'm pretty sure that I'm saying the truth, but I'm not an attorney. So, but I appreciate you being here, Treetop View. Because yeah, I didn't realize it either. I didn't realize how naive I was about a lot of this stuff either. I mean, I had certain feelings about things, but until you start following some of these cases like this, it's hard to know, what exactly is going on. I'm not sure the argument in terms of the speedy trial, right? Like that whole thing was like, interesting to me because, he waived his right to a speedy trial, which I understand why he did it, because they weren't getting the information that they needed from the state. And so to me, personally, if I was thinking about like if I was in that position, I don't know how you guys feel, but I felt like I would never waive my speedy trial. I just think it's a really bad idea to waive your speedy trial. I think they did it because they didn't have the information they needed and they didn't want to be ambushed at, when it came to trial, right? So the state attorney, that guy Jeff Nye, interesting. He's the one talking now, not Bill Thompson. I don't think Bill Thompson could handle these arguments in any capacity. he just didn't seem to have any of that type of finesse. And he's so emotional, he can't control any of these outbursts that he feels. So Jeff Nye is up there arguing, and he says, well, they didn't have, if they didn't waive their speedy trial, they could have just asked for a continuance. That's an interesting point, and I didn't know that. So I don't know. I'm kind of confused now about this whole speedy trial thing. And I thought it was a bad idea to begin with when he waived it, because if what the state was saying is true, if their claims that they didn't have the evidence to turn over was true, then how could they even move forward with the case, right? Like if they're saying, well, we don't have what you're asking for, we don't have this, we don't have that, well then shit, let's go to trial now, because if you don't have it, you can't present it at trial because that's by ambush. And so I would be freed. I mean, in my opinion, that was the way to go. I don't know what you guys think of all that, but again, yeah. He made a mistake by waiving it. That's exactly what I agree with that 100%. I thought he made a mistake by waiving it. And and I think the other attorney saying, you could have just asked for continuance or whatever, that makes sense to me. That makes sense. And so I just feel like it's never a good idea to waive speedy trial, but that's just what I've gathered. I'm not an attorney. It just doesn't make any sense, right? So it doesn't make any sense. I don't know what this guy is saying. Bye. Okay. Bye. You buying something or you saying goodbye, Giovanni? I don't know. Hey, sweet and salty. Just looking at the trial here. Biggest thing I noticed right off the bat is that Thompson isn't here, guys. Like Thompson is not here, and it's just like one of those things where it's one of those things where like I it's kind of interesting, right? Like, what do you guys think about it? Where's Thompson? Where's Bill Thompson? Is he never going to show up again? I mean, we know he was butthurt about the fact that he was going to have to drive all the way to Boise, right? And I personally, in my opinion, Bill Thompson is not qualified to try a case of this magnitude. And I think Jeff Nye knows that. And so does Ingrid Beatty. And honestly, I think it was always going to be them when it got to the level of this, when they were starting. He is on Zoom. So, okay, he's on Zoom. And then this says he was on standby by Zoom, I think they said. So, okay. So, yeah, I mean, I guess the question then is, who said he was on standby and did anybody actually see him, right? Either way, so let's say he is there. Let's assume that he's there. You guys are seeing him there. He's not arguing, right? He's not arguing. And I think it's going to stay that way. I don't believe that Bill Thompson is the one to take this case to trial. He just doesn't have the finesse or the emotional maturity, in my opinion, to deal with this case. He can't handle it, I mean, that's my opinion, just from what I saw in the trial over in Latah County. He just has these emotional outbursts and he says these things that I think are radical. And, it's just, it may work if you're in a little Latah County courtroom and, you're used to getting your way, but it's not going to work, particularly on a national stage and in front of a different judge, which, we now have what I believe to be a judge who is competent to try this case. I'm not shitting on John Judge in the sense that I think he's a bad person or a moral person. I think he's just not the type of judge that has the intellectual capacity. And I'm not calling him stupid. I just feel like he doesn't know the law. And you know what it is? I think the experience. He just doesn't have the experience to try a case of this magnitude. When you try a case of this magnitude, what you would hope for is a judge who knows, precedents, who knows case law, who knows the right questions to ask. And in this judge, I believe we have someone like that. He's one of those nerdy judges who went into the law because he cares about the finer points, and he's asking tough questions to both sides. And that's what you want for a fair trial. So I'm optimistic about this judge that he is going to give a fair trial, which is all I think we all want. Is in order for justice to prevail, it needs to be a fair trial. We don't have a fair trial in the Richard Allen case. If you're following it at all, that is an example of the most unfair and biased trial that could be. And we can't even watch it. We're getting secondhand information. Now, it depends on who you trust, but I trust Andrea Burkhart, and I believe she has a strong moral compass and is very ethical, and she's presenting all the facts. The very fact that we can't even see the court in Richard Allen's case, in my opinion, is their first clue that there's shady business going on. So, regardless, that's a talk for another day. But yeah, I think that this is good. I like the way it's going forward. I'm optimistic that this will be a fair trial. Okay, he says Bill Thompson will be presenting this case. LOL. He has a wealth of experience. Does he have experience prosecuting death penalty cases? Giovanni, do you know if he has experience prosecuting death penalty cases? And I mean, I'll have to take your word for it, because I'm basing my opinion off of Bill Thompson's actions and behavior. And when I look at Bill Thompson's actions and behavior, it shows me someone who is unable to control their emotions, which means he's pretty immature. And he is someone who is overbearing. And so that to me does not scream wealth of experience in trial. But that's my opinion. I could be wrong. Maybe he has a whole long list of death penalty cases that he's prosecuted and done well with. So, I'm just basing it simply off of my observation of the man. And, it's an opinion, right? You can take it or leave it. We all have them. And, Bill Thompson to me is not a very, he just doesn't seem like the type of person who is able to reflect, self-reflection, have insight, that kind of stuff, versus this guy, Jeff Nye. He seems like a man who understands the law. He has good points. He's not having angry outbursts and making faces and getting upset and scolding the judge. I mean, it's just like a total opposite, if you ask me. So yeah, that's curious. I'd really like to know how many people Bill Thompson has prosecuted for murder. Not all lawyers are cut out for trials. Some lawyers are and prosecutors are, cut from a different cloth. It takes a lot to know how to operate in a trial. And that's why they got Eliza Mazoth on the defense side. And it was a great move on Ann's part to get her. She is a very experienced trial attorney. I do know this about her because I looked into her history when everyone was shitting on Bryan's defense team. And I made that video months ago, because Eliza Mazoth is a woman who was able to overturn a death conviction. A convicted murderer in Idaho was taken and freed because of Eliza Mazoth. So she is a very smart woman, and she is good at representing herself. And so, to me, even if I hadn't read her history, you can just tell by her presence in court that she is very comfortable with her knowledge and confident about it. She has the case law. She's not up there, making emotional outbursts and things like this. I'm sorry. I think I just have little respect for anybody who cannot control emotional outbursts, but particularly for anybody who is in a court of law, in the public view, in such a important case who can't control their emotions. I have such little faith in that person. Because if you don't have faith in yourself that you can stand up with a strong voice and present things and be confident, what are you doing there? What exactly are you doing there? You're too emotional, and emotion is not justice. It has nothing to do with justice. So, that's my feelings on it. Let's see what else you guys are saying. Interested in seeing John, Judge, and BT in a case that wasn't so public. Yeah, I mean, look, they could be great in these other cases, and we don't know. This is an unfair critique in the sense that I'm just picking out something and looking at it. But it's the same thing with anything. You have to know what you know and know what you don't know. And in this case, because it has international attention, they're going to get public scrutiny, and I have a lot to scrutinize on their part. Not John Judge so much as that I think it's nefarious in any way, and even Bill Thompson. I don't think that there's something that they're out to get people or whatever. I think that it's small town politics. It's small town politics. It's biases that they have that they're not even aware of. In a case of this magnitude, it's just going to blow up and everybody is going to see them, right? So, who's this self-proclaimed YouTube trial lawyer with 6 months experience? Who are you talking about, 12 gauge? I'm not sure. But yeah, it's just like one of those things, like, it's tough. I mean, I don't envy the position. And again, John Judge, I think, from my perspective, just seemed like one of these sort of small town judges. And I don't think he wanted to be on this case from the beginning. From what I saw, and again, this is me, my life experience, looking at somebody and the way they behave. I just don't. He just didn't seem like the type of judge who really wanted to be in this situation. I think he recognized the scrutiny that it would entail. Oh, you're talking about yourself. Yeah. Look, we can all critique things. I just try to critique things in a fair and balanced way. I'm not, look, you could look there. I've seen a lot of trials at this point. Okay. I mean, I've watched a lot of trials. I started really getting into trials after the Murdaugh case. And the judge in the Murdaugh case I thought was excellent. I watched the Leilani Simon trial. That judge she was phenomenal. I think she was probably my favorite judge of all time. The Leilani Simon judge. I don't know her name. I'm blanking on it. But that woman is the epitome of a fair judge. She was incredible. She was, she was unbiased to both the defense and the prosecution. And Leilani got a fair trial. She got what she deserved. Okay. I think we all know that. But yeah, I just, you start critiquing judges because you're watching them all the time. And it's just like any other profession. Some are really, really good and some are not so good. Some don't even know the law. Oh, thank you. Thanks, 12 gauge. I appreciate that. I honestly try to respect everybody's opinion here because I'm just one of those people that I will always see the other person's side. And I think that's a trait of mine that I have. I've always been that way. I've been the diplomat or the peacekeeper. It's my personality to be that way. I feel like there's always a way to meet in the middle. In some cases, though, there is not. There is only one answer, right? I mean, if you want to be a person of integrity, they say stand for something or fall for everything. And that's something I recognized, at some point, there are some things that are just right and wrong, and there is no other side to it, right? And so killing and murdering 4 people like this is wrong, period. But until we get to trial, until both sides present all the evidence, I haven't made up my mind yet. I can just tell you that, like the Richard Allen case, I'm not seeing a whole lot here that the state has presented to make me confident that they have a good case. That could change. But you know, I am not a person who thinks that every person that is arrested and alleged to have done something is, you know, innocent. You know, I presume their innocence 100%, but there are some cases that it's pretty obvious, right? Like with the Leilani Simon case, like I wasn't sitting there saying, gee, like, I don't think she did this. I think, you know, other people are. I wasn't doing that because the evidence was pretty clear, right? The evidence was pretty clear. Just like with the Madeline Soto case, right? You're not going to see me picking apart the prosecution and this kind of stuff. Like I watched those videos and everything, and I saw, and it was really clear that Stephen Stearns is involved. And I also believe that Madeline Soto's mother is somewhat involved in this too, right? That there's nothing. I think the state has a very strong case. I'm still interested in watching the trial, but the state in that position has a very strong case. Yes, Stephen Stearns is presumed innocent, right? But that's a case where things are pretty much looking like, yeah, the state got the right person. They did it the right way, which is just as important. It's not about just getting the right person. It's about doing it within the bounds of the law, because that also matters to me. If they got the right person, but they did it illegally, then they have to throw it out, even if it's the right person. If we don't have that, then we're not living in, you know, in the United States of America. We're living in another country, and you can't do it for just one person, even if it sucks, right? Even if it sucks. So that's just the way I feel about it. And so I do, you know, and here's the other thing. When people start name calling, whether it's the defendant is innocent or guilty, and start fighting over it and name calling it, to me, it's just, it's silly. It's a silly thing to do. Because really what all we want is justice. I think when people start getting into these personal attacks, you know, then they're making it about them. They're making it about them and their opinion. This isn't about me or my opinion. This is about justice. What I expect from our system, what we pay these people to do, right? It's about justice, and that's what I expect. It's not about me at all. I'll admit I can be wrong about a lot of stuff. I can be wrong about all of this. It's just my opinion, right? And I think people share my opinion, and some people don't, and that's okay. I think it is a disgrace and dishonor to the victims of any case when people start arguing about stuff like he's definitely innocent and I can't believe blah blah blah, or he's definitely guilty and blah 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 blah. It's like, you're dishonoring the victims. You're dishonoring the victims. If you want to say it's all about the victims, that there's no honor and respect to victims or justice when people behave that way. And so I don't know. I guess that's just my point of view. And I'm glad that other people care enough about it to listen and join me here and discuss it. Your outlook and truly accepting of all opinions is why I came here to watch this. Thank you, Treetop View. I appreciate that. I mean, that's really my goal here. I really do want to hear other people's opinions, even opposing opinions, and challenging my opinions and all those things. I'm never going to get mad at somebody because they say, you know, what I'm saying and they disagree with, or they question it, or they present the facts to oppose my opinion. I'm going to look at it. And if I'm wrong, I might not agree with you immediately because I'm a skeptic by nature. I've always been that way. And I question authority, have always been that way. That is something that is innate and probably genetic in some fashion. So I will listen to what someone says that's opposing to what I believe, and I'll look into it. And if I agree, you might have just changed my mind. And I've changed my mind many times on many things. So that's what I want this to be for everybody here. I want this to be a place where people feel safe in expressing their opinions about things, whether this or that, and just no name calling and that kind of stuff. Because I honestly, I mean, you know what, even when I was a kid, I didn't have time for that. Like, I just never did, you know, I've never been that person to go around and like do that. I have no time for gossip. I'm not a gossiper. I know I'm a woman and a lot of women gossip, but you know what? Men gossip too. Some men gossip more than any women I've ever met. So Anyway, I'm going to head out of here, guys. I know that there's probably more coming up on the trial, but I have some things to do. I just want to jump on here and, you know, just talk about it. So I appreciate everybody for coming and joining me with this. And, you know, anytime there's a live streaming for this, I'm going to try to put it up on my channel so that we can all discuss it. I was over, oh, Jory has the case. I am super interested in this. Oh my gosh, I am so interested in this case, the Delphi case. I pray they get it right. I pray they get it right. But yeah, so yeah, I want this to be a place where people would talk, because you know what? I started watching this and I was watching it on Long Crime, and everybody in there was just like they're already convinced that Bryan Kohberger is guilty, and the bias was so loud and clear and obvious, and it irritated me because I felt like I know there's people like me who aren't convinced he's guilty yet and are presuming innocence and want to just discuss it, right? So I do want it to be a safe place for people of all opinions to come and talk about it. So that's why I came on, and I'm going to try to come on anytime there's a live stream here. But thank you, everybody for coming and listening to me. I always appreciate it. And let's just take it out with my favorite song, because it really just embodies, you know, if I can find it, of course. I don't know if I can find it. Here we go.
Cause I don't give a fuck what you say. Yeah, I'ma do shit my way. So you can go kick rocks, I'ma stack bricks up, build what I want to make. Yo, I got a lot of shit to say, so I'ma do this every day. I'll be writing things until I'm fucking buried in my grave. 6 feet deep under, but my body won't decay. Cause my messages are timeless, so they'll put them on display. Oh yeah, I rap with a certainty, I have a sense of urgency. A message for eternity, for everyone internally. I had some people burning me, but now they fucking learn to see I ain't the one to fuck with. Now they looking nervously, and I don't really care what you think of me respectfully. You can kick rocks if you think you're fucking better, see. I will outwork you, turn you to an enemy. Hurt you so bad that you're gonna need some therapy. I got the motherfucking recipe. I've been cooking up hits, I'ma leave a legacy. You'll be looking small when you're standing right next to me. I'm 5'10", bitch, but I'm 10 feet next to me. I don't give a fuck what you say. Yeah, I'ma do shit my way. So you can go kick rocks, I'ma stack bricks up, build what I want to make. Cause I don't give a fuck what you say. Yeah, I'ma do shit my way. So you can go kick rocks, I'ma stack bricks up, build what I want to make. Yeah, I'ma do it my way.